Hello, everyone, and welcome to today's National NAGPRA Program webinar. This is the 9th webinar in our series this year related to the revised regulations. This webinar is being recorded, and the names of those in attendance will be captured through the Zoom registration feature. If you do not wish to have your name recorded as attending this webinar, you may disconnect at this time. So as I said, today's webinar is the 9th in a series of webinars that we have hosted since January on a variety of topics related to NAGPRA. And today's webinar will focus on the civil penalties provisions of NAGPRA, and in particular, the civil penalties provisions in the revised regulations. I don't have a PowerPoint prepared for today. Instead, what I'd like to do is walk you through resources that are available online and related to civil penalties under NAGPRA. So if you will give me just a minute to share my screen. As a reminder, this webinar, as in all of our previous webinars, will have an opportunity for Q&A at the end of the session. And right now, the Q&A and the chat are not available, but they will be made available after the presentation. Please do not raise your hands. We are unable to monitor the hand raising, but please do prepare to ask questions in the Q&A function at the end of the webinar. Okay, so I am sharing my screen with you, which is the National NAGPRA Program's webpage. And for those of you who are listening only, this is the National NAGPRA Program webpage, can be found at nps.gov, NPS for National Park Service.gov/NAGPRA. That's the easiest way to get there. I will also add that in the chat for those of you who are online, in case you are unfamiliar with that website. But hopefully all of you are very familiar with this website because it, again, has a lot of information about NAGPRA. This is where we're starting today with our discussion. So again, this is an incredibly useful tool for any of you that are wanting to learn more about NAGPRA and about the NAGPRA process. The website was fully updated earlier this year based on the revised regulations and reflects those changes. And so for my presentation today, I'd like to walk through some of the resources that are available, in particular, those resources about civil penalties. So turning first to the menu for this website, you'll see that enforcement is a tab or a section of this website. The enforcement page of our website includes information on the two pieces of enforcement that are contained in the law itself. So first are the criminal provisions that are provided under NAGPRA, again, for criminal violations of the law. And then the civil provisions of the law. And at the bottom of this web page, you'll see the exact language from the law itself. And the citation to the U.S. Code, where you can find these specific provisions from NAGPRA. And I will mention that there was an update to the criminal provisions under 18 U.S.C. 1170, an increase in the maximum penalties in especially the maximum imprisonment time for violations of NAGPRA under the criminal provisions. And we've made that update here. So again, the language from the law itself is here on our website. And again, you'll see that the first provisions are those in 18 U.S. Code 1170 for illegal trafficking of Native American human remains and cultural items. But our focus for today is on 25 U.S. Code 3007, which are the civil penalty provisions under NAGPRA. And the language from the law, again, is here in front of you. Any museum that fails to comply with the requirements of NAGPRA may be assessed a civil penalty by the Secretary of the Interior. And that process of assessing a penalty is through the procedures that are established in the regulations. There are some broad outlines here of the ways that penalties can be assessed, and the amount of penalties in particular. The law provides some guidance on the amount of a penalty and how other factors may be considered in assessing that penalty amount. And then the actions that can be taken to recover the penalty amount. So this language here, these 4 paragraphs, is what we have provided in the Act for the civil penalty process under NAGPRA. And of course, key to this is the procedures that are established by the Secretary through regulations. So again, looking at this page, and let me just put this in the chat for any of you that need the direct link. If I can find my screen, just a moment. There is a direct link to the page that is on your screen right now. The civil provisions in particular, again, provide that any museum that fails to comply with the requirements of NAGPRA or the regulations may be assessed a civil penalty by the Department of the Interior. And each instance of failure to comply constitutes a separate violation. These provisions do not apply to federal agencies. A federal agency's failure to comply is subject to other remedies under federal law, but not the civil penalty provisions. So again, our discussion today on civil penalties under NAGPRA only applies to museums, not federal agencies. Any person may file an allegation of a failure to comply by sending an allegation to my office at nagpra_info@nps.gov. We include here on the webpage some ways that a museum might fail to comply, but this is not an exhaustive list. These are just some ways that a museum may fail to comply. For example, a museum may transfer human remains or cultural items to an individual or institution that is not required to comply with NAGPRA, and that could be a failure to comply. A museum that does not complete a summary by the required deadline may have failed to comply. A museum that does not complete or update an inventory by the required deadline may have failed to comply. A museum that does not submit a notice of inventory completion or a notice of intended repatriation by the required deadline may have failed to comply. A museum that does not send a repatriation statement by the required deadline may have failed to comply with NAGPRA. Sending a repatriation statement, or I would add here, transferring human remains or cultural items before publishing a notice in the Federal Register could be a failure to comply. Not consulting with lineal descendants, Indian tribes, or traditional religious leaders who request to consult could be a failure to comply. And I should say we need to add Native Hawaiian organizations to number 7. That was an oversight on our part. And then again, another way that a museum may have failed to comply is by not informing requesters of potentially hazardous substances that were used to treat objects. So again, this list are those ways that a museum might have failed to comply. It is not an exhaustive list. It is just a list of some ways that a museum may have failed to comply. From this page, you can dig a little bit deeper into the civil penalties through the secondary page that we have here. on civil penalties in particular. And this page goes through a series of specific questions and answers related to the civil penalty process. Again, civil penalties may be assessed against any museum that fails to comply with NAGPRA. And we have repeated here the definition for museum to be clear that a museum means any institution or state or local government agency, including institutions of higher learning, that have possession or control of human remains, funerary objects, sacred objects, or objects of cultural patrimony, and receive federal funds. That is the definition of museum. So any museum can fail to comply, and any person can allege a failure to comply. Allegations must be sent in writing and must identify the failure to comply and any supporting facts. Again, an allegation in writing means an email is sufficient as a means of submitting an allegation in writing. What happens after you submit an allegation? The National NAGPRA program will acknowledge receipt of the allegation to the person who made it, and then coordinate on an investigation of the facts. What happens when an investigation is complete? Well, the Assistant Secretary for Fish, Wildlife, and Parks will notify the museum of the results of the investigation and will send a copy to the person who made the allegation, the complainant. The Assistant Secretary may determine that a museum has failed to comply with NAGPRA, or the Assistant Secretary may determine that the evidence does not support the allegation. What if my museum is out of compliance? Any museum that believes its compliance with NAGPRA is in question can always contact my office, me, Melanie O'Brien, the manager of the National NAGPRA program, for technical assistance to ensure that the museum has met its statutory and regulatory responsibilities. And coming into compliance with NAGPRA will not necessarily affect the investigation of an allegation that a museum has previously failed to comply. But efforts to mitigate a violation are certainly taken into account by the Assistant Secretary in determining a penalty amount and whether or not a penalty is appropriate. The rest of this page outlines options that are available to museums if they do receive a written notice of failure to comply from the Assistant Secretary. After receiving a notice of failure to comply, a museum may request informal discussion with the Department of the Interior. They may request an administrative hearing on the determinations of failure to comply, or they may take no actions and wait to be assessed a penalty. What are the options available to a museum that has been assessed a penalty? The Assistant Secretary determines if a penalty will be assessed after that first notice of failure to comply. And at that time, then the museum has options for responding to a penalty assessment. So again, we're going to hold all questions until the end after the presentation, and please do not raise your hand. I'm unable to manage live questions during the presentation, but there will be time at the end of the session for questions. So again, these web pages that I'm sharing with you are our public presentation of the detailed information that's contained in the regulations themselves about failures to comply and how allegations may be made, and the options for museums in responding to those. But there is a lot more information for all of you related to the civil penalty process that can be found in the regulations themselves. Before we jump into the regulations themselves, I also wanted to point out some additional information about past civil penalties. The National NAGPRA program issues annual program reports, which can be found on our website under program reports. I will again post the link for everyone. And these program reports, of course, go back to 2002 here on our webpage. And the recent reports in 2022 and 2023 have provided some additional information on civil penalties that I wanted to share here today. So in looking at the 2022 program report, again, this is, you can access that here from the reports page. I just have pulled these up so they'd be ready to share. And in the 2022 program report, I guess this is page 9, is the section on civil enforcement and a summary of actions by the NAGPRA program, the National NAGPRA program, related to civil enforcement. Now, it's important to note that in the 2022 program report, we did provide some revisions to how we were reporting on civil enforcement. Prior to 2019, the program had reported information in other annual reports, including the number of allegations, the number of violations, and the number of unique entities involved in those allegations. In 2022, we revised how we reported that information in order to ensure that we were being more accurate and a little bit clearer about this statistical information. So as a result, the statistics that we reported in 2022 differ a little bit from what was previously reported. Since 1996, the program has received 122 unique allegations of failure to comply. Again, this is from the 2022 report. And again, it differs from past reporting, and that's just tried to clarify that here in the 2022 report. But you can see that those allegations that we received, 23 of those allegations were substantiated, meaning that there was a failure to comply that was found as a result of that allegation. And then for 36 of those allegations, they were not substantiated. In other words, there was no failure to comply. And then the balance of those allegations was still pending. We further explained that of the 23 allegations that were substantiated, the Assistant Secretary for Fish, Wildlife, and Parks assessed penalties in response to 12 allegations, and that 11 assessments have been paid as of 2022. And then in 2022, for the first time, we reported a list of those allegations that were substantiated and that had penalties assessed and penalties paid. In addition, there were some of those in which a penalty was determined to not be the appropriate remedy for 7 of those allegations. So those are indicated in this table here, that the assessment of a penalty was not the appropriate remedy, and therefore there's no penalty amount in the table. And in addition to that, there were 4 allegations that were settled without payment, and those are indicated again in the table. There are 3 settled without payment and 1 settlement with payment. So altogether, since 1996, the civil enforcement under NAGPRA has yielded $59,000 in penalties and settlements that have been paid to the U.S. Treasury. Now, money collected through the civil penalties goes to the general accounts of the U.S. Treasury. It does not come back to the National NAGPRA program or to the NAGPRA process, but rather goes to the general accounts of the U.S. Treasury. In addition, the 2022 report includes additional information about the 63 allegations that were still pending. And we provided here a breakdown of the status of those allegations that were pending and those that were under investigation. Here I'm going to switch over to the 2023 report where we updated this information again. Here on page 7 of the 2023 report, we provided information that there were 13 allegations we received during that fiscal year of 2023, bringing the total to 135 allegations. And then again, the same table that reflects those allegations that were substantiated and then the allegations that were still pending as of September 30th, 2023. Again, we provide these annual reports at the end of each fiscal year, and we are just 10 days away from the end of this fiscal year. So you can expect a program report to be posted to our website in the coming weeks. We try our best to have that program report out as quickly as possible, but it does sometimes take us a few weeks to get all of these numbers pulled together and put into the report. But you can expect a program report for information from 2024 to be coming soon. And we'll again provide this information about allegations that have been received, allegations that have been substantiated, and then allegations that are still pending. So that is where you can find information on the past practice of civil penalties. And now I want to turn to the current regulations and the requirements in those regulations for civil penalties. Here I will also share a link. Let me see. Yes. Hopefully, again, you're all very familiar with the revised regulations and how you can access them through the website called ECFR. And that stands for Electronic Code of Federal Regulations. This is the easiest way to see the current regulations. And what I've put in the chat is a link directly to section 10.11, which is the civil penalties provisions. So again, much of the information here is the same as what you saw on the webpage, almost in many cases verbatim, but again, the regulations are the official source for information on civil penalties and how the civil penalty process is laid out by the department in these regulations and in the revised regulations that were published in December of last year and became effective in January. So again, any museum that fails to comply with the requirements of the Act or this subpart, meaning Subpart C, the repatriation provisions, may be assessed a civil penalty by the Secretary of the Interior. Now, it's important to note that here we're only talking about museums, again, as mentioned before. And as the next sentence explains, this section does not apply to federal agencies, but federal agencies' failures to comply with the requirements of the Act or the part may be subject to other remedies. Again, it's important to note that this only applies to museums, and again, it only applies to Subpart C, the repatriation of human remains or cultural items by museums. Each instance of failure to comply constitutes a separate violation, and the Assistant Secretary must serve the museum with a written notice of failure to comply or a notice of assessment, and then the particulars on how those are delivered. So there is a requirement by the Assistant Secretary to deliver those notices of failure to comply by personal delivery, certified mail, or private delivery service. Again, these instructions and the regulations relate to the requirements on the Assistant Secretary, which in the revised regulations is defined as the Assistant Secretary for Fish and Wildlife and Parks, who has the delegated responsibilities from the Secretary of the Interior for civil penalties. So throughout these regulations, you're going to see a reference to the Assistant Secretary. And again, that is the Assistant Secretary for Fish and Wildlife and Parks, as defined in these regulations. So paragraph A, again, goes over the options for filing an allegation. And again, any person may file an allegation of failure to comply by sending a written allegation to the manager of the National NAGPRA program. The allegation does need to include the name and contact information, some way of contacting the person alleging the failure to comply. The allegation must identify specific provisions of the act or the subpart that the museum has alleged to violate. So again, what is the violation here that is being alleged? And where possible, an allegation may enumerate the separate violations alleged, including the number of separate violations, if that can be identified. Again, there's a difference here between the must requirements, and the allegation must identify those provisions that have been violated. And if possible, the allegation may enumerate separate violations. It may be that the person making the allegation can't enumerate those separate violations, but where possible, that information is very useful, especially the number of Indian tribes or NHOs that are aggrieved by the failure, or the number of individuals or funerary objects or sacred objects involved in the failure to comply. Again, an allegation may include information to show that the museum has possession or control of human remains or cultural items, and may include information showing that the museum receives federal funds. So these 5 points here for the allegation, there are two things that we must have. We must have the name and contact information for the person making the allegation, and then what the violation is. In addition to that, additional information provided in the allegation, including the number of violations, information about possession or control, and information about receipt of federal funds, are incredibly helpful in evaluating the allegation. Paragraph B in the regulations provides what is required once we receive an allegation. No later than 90 days after receiving an allegation, the Assistant Secretary must determine if the allegation meets those requirements that we just talked about in paragraph A, and must respond to the person making the allegation. So you will, upon submitting an allegation, you'll receive an immediate response that it was received, but then 90 days after submission of an allegation, you will receive a determination if the allegation has met the criteria. And for allegations that meet the criteria, then the next paragraphs provide the specific kinds of responses that the Assistant Secretary can provide in response to that allegation. So the Assistant Secretary can ask for additional information, either from the person that made the allegation, the museum, or other parties. And the Assistant Secretary may conduct an investigation to determine if the alleged failure to comply is substantiated. And then in response to an allegation that meets the criteria, the Assistant Secretary will review all that relevant information and make a determination of one of the three following responses: either that the alleged failure is substantiated and a civil penalty is an appropriate remedy, the alleged failure to comply is substantiated, but a civil penalty is not an appropriate remedy, is the second option. And then the third option is that the alleged failure to comply is unsubstantiated. So those are the three options for the Assistant Secretary after an investigation or additional information about the allegation is reviewed. It's important to note that while there's a timeline attached to the response, the 90 days to respond to the allegation, there is no timeline for the Assistant Secretary to make the determination about the alleged failure to comply. And that's because this process of gathering information and especially the investigation that may be necessary is an indefinite time period, or is not time limited necessarily. There may be reasons why that period may require additional time for the investigation, or to get additional information either from the museum or other parties. But there is a prescribed outcome to that allegation, and it's one of these three options. Following that, the Assistant Secretary then also calculates a civil penalty if the civil penalty is an appropriate remedy. So again, under that first response option, where a failure to comply is substantiated and a civil penalty is an appropriate remedy, the Assistant Secretary must also calculate the penalty amount. And the penalty amount is calculated, again, using these specific regulations and this specific process. Each separate violation is calculated first using a base penalty amount, which is currently $8,315. That amount is adjusted annually for inflation. So every year it goes up with the Federal Civil Penalty Inflation Act requirements. In addition to the base penalty amount may be increased after considering certain factors. Again, if you remember at the very beginning, we talked about what the law provides, that a penalty may be adjusted based on certain factors. And the regulations provide these 5 factors that a penalty amount may be increased after considering. The first is the ceremonial or cultural value of the human remains involved, as identified by the aggrieved parties in particular. The second way that a base penalty amount might be increased is through the archaeological, historical, or commercial value of the human remains or cultural items involved. The third is either through economic or non-economic damages that were suffered by the aggrieved parties, including the expenditures of aggrieved parties to compel the museum to comply. The fourth way a penalty may be increased is the number of prior violations that the museum that have occurred. And the fifth is any other appropriate factor that justifies an increase to that base penalty amount. In addition to the ways that a penalty amount may be increased, a penalty amount may also be reduced. The base penalty may be reduced if the museum has come into compliance, if the museum has agreed to mitigate the violation through either an actual or in-kind payment to the aggrieved parties. A penalty amount may be reduced if the penalty constitutes excessive punishment under the circumstances. And the penalty amount may be reduced if the museum is unable to pay the full penalty amount. There is additional information that would be required there for that reduction. And then the last option to reduce a penalty amount is other appropriate factors. So again, that is how the process by which the Assistant Secretary calculates the penalty amount, where an allegation is substantiated and a penalty is the appropriate remedy. So this first option. Where a penalty is substantiated, under that paragraph B, either substantiated with a penalty as an appropriate remedy or substantiated and a penalty is not an appropriate remedy. In either case, the Assistant Secretary must notify the museum of the failure to comply. And the Assistant Secretary must do so in a written notice of failure to comply. And a copy of that notice is sent to the person who alleged the failure to comply, as well as to any lineal descendant, Indian tribe, or NHO named in the notice of failure to comply. And these 6 items are what the notice of failure to comply must contain. Must contain a concise statement of facts about the failure to comply, a reference to the specific provisions of the Act or the regulations with which the museum has failed to comply. The proposed penalty amount, if a penalty is an appropriate remedy, must also be included in the notice of failure to comply. And where appropriate, any initial proposal to reduce or increase the penalty amount, as well as an explanation of that determination, or an explanation of the determination that a penalty is not appropriate. In addition, the notice of failure to comply must identify the options for responding to the notice and inform the museum that the Assistant Secretary may assess a daily penalty amount if the failure to comply continues. And there's additional information later on in these regulations about the daily penalty amount. And then again, as outlined on our webpage, in more sort of simple terms, there are options here for how a museum may respond to that notice of failure to comply. In response to a notice of failure to comply, a museum may seek informal discussions about the failure to comply, may request relief from the Assistant Secretary for the for the failure to comply, and or three, the museum may accept the determination of a failure to comply and agree in writing, again, to pay the penalty amount, or complete mitigation to reduce the penalty. And in that written acceptance of the penalty of the failure, the museum would waive any right to receive a notice of assessment or to request a hearing. So these are the three options that a museum may take following a notice of failure to comply. After a notice of failure to comply, the Assistant Secretary then assesses the penalty. Again, it will the penalty assessment will depend on the responses from the museum to the first notice of failure to comply. But then following that, the Assistant Secretary will issue an assessment. And the Assistant Secretary will again notify the museum of the assessment. And the particulars of that notice of assessment are detailed here in the regulations. And then there are options for a museum to respond to an assessment. And then the last part of these regulations cover the options for a museum to request a hearing on either the notice of failure to comply, and the notice of assessment. And then there's additional details here about the hearing process, as well as appeals to that decision. And then, as I mentioned, the procedures here for a daily penalty, where the failure to comply continues after the final date of the date of the final administrative decision of the Assistant Secretary takes effect. And that's particular points in the process at which that final administrative decision occurs. I appreciate and probably have lost a lot of you in my reading of the regulations. But I wanted to be clear that this is a very specific process, and there are specific procedures included in these regulations for civil penalties. Again, as required by the law, civil penalties must follow the process that's outlined through the regulations. So there is an incredibly detailed process here in the regulations for how the civil penalties are how failures to comply are determined, and then how civil penalties are assessed. The basics are, of course, again, that any person may file an allegation. The secretary, the Assistant Secretary, will evaluate all allegations that are received. And then after the evaluation of those allegations, the Assistant Secretary has three options for responding to the allegation. Those are that the allegation is substantiated, and if civil penalty is an appropriate remedy. The allegation is substantiated, but a penalty is not an appropriate remedy, or that the penalty is unsubstantiated. So again, there's a lot of detail here, and there are a lot of specifics, but it's important to realize that's necessary to clarify this process. Now, one question some of you may be asking is, if you're still awake, is how does this change? How is this different than the previous regulations? As you all know, the Department of the Interior issued the final regulations in December of 23. They became effective in January. And prior to that, the department published a proposed regulation and requested public comment on those proposed regulations. So again, we have detailed discussion in the final regulations, again, published in December of 23, about the civil penalty process. And these comments here, and I've put a link to this specific paragraph, this section of the final regulations and the comments and responses summarize the comments that we received on civil penalties and our responses to those comments. So you can see here that we received 30 comments generally on the civil penalties provisions. And then we summarize in the rest of this paragraph what those comments, what those comments said. So 12 of those comments, 12 of the 30 comments generally supported the civil penalties section as proposed. 9 comments requested the regulations add procedures for investigating federal agency failures to comply. 3 comments objected to the revisions of the section and requested that we retained more limited categories of a failure to comply. So the previous regulations included specifically 9 ways that a museum may fail to comply. And these regulations have removed those specific 9 ways. 1 comment stated that, as proposed, the regulations ensure all museums will fail to comply with the requirements of the Act. 3 comments requested clarification if certain actions like releasing sensitive information would be a failure to comply. And 1 comment requested clarification on museums with custody of federal holdings or collections. And then 1 comment provided specific suggestions. And then again, our response. And as I stated multiple times here, the civil penalty provisions do not apply to federal agencies. And our response to the comments requesting that we do so was that we cannot expand this section to include federal agencies. Federal agencies are not subject to the civil penalty provisions of the Act, and any change would be inconsistent with the Act itself. We could not elaborate or reference the federal laws that federal agencies are subject to, but broadly, the most broadly applicable way to allege that a federal agency has failed to comply with the Act or the regulations is to send an allegation to the head of the appropriate federal agency or to the federal agency's office of the Inspector General. Those are general ways that you may allege a failure to comply with NAGPRA in particular, but those are the ways that you indicate a federal agency's failure to comply with other laws as well. So we provide that information here on federal agency compliance. In response to the comments that requested that we limit the ways that a museum may fail to comply, we did not make that revision, that requested revision to go back to the limited ways a museum may fail to comply that were in the previous regulations. Rather, all of the requirements in Subpart C of the regulations are subject to a civil penalty. We provide very clear timelines for museums after the effective date of the regulations for compliance with these requirements. And so it is those timelines that indicate when a museum has failed to comply if they fail to meet those timelines. And museums should carefully consider these timelines when they are exercising discretion on how to complete the required tasks. We provide an example here that a museum has discretion in how it compiles its itemized list of human remains and associated funerary objects. It must do so within a certain time frame, and so how it exercises that discretion must fit within that time frame, or the museum is risking that it will have failed to comply. Specific actions like failing to protect sensitive information, whether that constitutes a failure to comply will depend on the specific circumstances involved. And then again, we indicate in response to the comments that a museum that has custody of federal holdings or collections has a responsibility for sending a statement under Section 10.8C by a certain deadline. That deadline is January of 2025, and a failure to do so could constitute a failure to comply under this section. So again, this section provides timelines and transparency whenever possible within the civil penalty process. But again, given the nature of investigations and civil penalties, not all parts of the process have a timeline or can be made public. That's in response to the request for very specific information or comments that we received. And then we go on to explain some of the other changes or comments that we received and changes that were made in the federal, in the final rule, especially in relationship to filing an allegation and responding to an allegation, calculating the penalty amount, notifying a museum. So you can see there are a total of 6 different comments and responses here. If you're interested in the specific comments that we received on civil penalties in particular, as hopefully everyone is aware, the comments on the proposed regulations are available publicly. I will provide a link here to the full docket, but in particular, I wanted to point out that if you were to go to the docket and all comments on the docket, you can put a search like civil penalty, and it will show you each of the comments that discussed civil penalties. And you can see here, again, some of the specific comments about changes to the civil penalties process, or also those comments that generally supported the proposed rule and the civil penalty process. So let me grab this link first for you. And then again, just remind you that you can use in the comments section, you can use the search function to find those comments that talk about civil penalties. If you want to read the comments that we received specifically, as opposed to the summary that I just showed you. Okay, I know that was a lot of information, and I do know that several people have raised their hands asking questions. I'm going to stop sharing, although I'm happy to pull up any of those particulars again if you do have questions. And I'm going to take just a minute to go ahead and turn on the Q&A so that you can ask questions. Again, as in past webinars, you are able to upvote questions. So you can indicate if somebody asks a question and you have the same question, you can upvote that. First question is not related to the topic of civil penalties, but it is about the NAGPRA grants and the next when is the next NAGPRA grant available? So right now, you can apply for NAGPRA repatriation grants. So again, repatriation grants you can apply for right now. Through May of next year, you can apply for repatriation grants. We have funding available for repatriation grants, so please apply. We anticipate having the next notice of funding opportunity available in November. That's our typical timeline for having a notice of funding opportunity available in November for fiscal year 25 consultation and documentation grants. So again, we anticipate having the notice of funding opportunity available in November. They'll have a specific due date in that notice for when grants are due. But again, the typical schedule is we announce the next fiscal year in November, and the grant applications are due in March. So for general planning purposes, the next grant opportunity for consultation and documentation grants will be open in November, and it will be due in March. But repatriation grants are currently available. Okay. A related question to both the question and the topic. Is museum compliance a factor in determining who receives the NPS NAGPRA grants? There is particulars in the grant process and in the grant application about compliance and in terms of completing initial inventories and summaries as a requirement for applying for a grant. In addition, museum compliance, it is not a direct factor in that, you know, a museum that has in the past failed to comply with NAGPRA and found to have failed to comply, if that failure has been remediated either through the payment or other ways, then it may be that going forward, that museum may be able to apply for a NAGPRA grant. Okay, I'm still confused about timelines. I can understand why. A museum where I currently work was in compliance with the law as it was originally written. With the new updates, we are working to update cultural affiliation of what was previously listed as culturally unidentifiable. We are also working to update and send out all of our cultural summaries. We have limited resources and staff, but we are actively working on this, and it is a big priority. I'm sure many of us are in the same boat where there's only one curator on staff. I'm wondering if there are specific timelines required to complete this work. I've seen things like 60 days to do this and 90 days to do that. However, it seems unrealistic to get everything done in a short amount of time. Do you have any insight on the actual timelines? I do have some insight on the actual timelines, and let me share my screen again. And I will add this again to the chat so you can find the direct link. On our website, under Law and Policy, if you go to the policy page, we have this document called Steps to Repatriation. And the steps to repatriation are for human remains and associated funerary objects. And then below this are the steps for other cultural items. But in particular, I wanted to draw your attention to this, page 3, which outlines the timelines for inventories and completing inventories. I appreciate your question, and I appreciate your specific question about the timelines for inventories. The deadline for updating inventories with cultural affiliation is January 10th, 2029. So again, for any human remains that have not been published in a notice of inventory completion, they must be put in an updated inventory that is due on January 10th, 2029. Now the question asks about additional work being done to update summaries. If a summary was completed in 1993, as was required under the law, or subsequently completed under another timeline, there's no requirement to update a summary. Let me just say again, there's no requirement in the revised regulations to update a summary. There is a requirement to update inventories. So that deadline for updating an inventory is January 10th of 2029. So to ensure compliance with the law and with the revised regulations, museums should focus on updates to their inventories. And keep in mind that an update to an inventory means completing steps 2, 3, and 4. Again, step 2 is initiating consultation, step 3 is consulting, and step 4 is completing, or in this case, updating an inventory. So the primary focus for museums should be in initiating consultation, or in many cases, reinitiating consultation on those human remains that have not been published in notices of inventory completion. Beyond those deadlines, once the inventory is complete or updated, then the additional timelines are laid out here. There is a 6-month timeline to submit a notice of inventory completion. And then the timelines that you're referring to, the 90 days, really come in response to requests for repatriation. So again, the obligation here and the deadline for updating an inventory is January 10th, 2029. Hopefully that helps. And let me put a link to this document in the chat for everyone. Okay, let me resort my questions. Again, you can upvote questions. If somebody asks something that you want to hear the answer to, it will raise to the top of my screen, and there's a better chance of it getting answered live. Although again, part of why we ask you to write your questions is so that we have a record of all of these questions, and we are working to compile those. Okay, the next upvoted question is, who receives the money from civil penalties? Mitigation, restitution, and many cultural regulations are intended to benefit the community of the potentially harmed. It doesn't seem like the penalties here are for the benefit of the communities harmed. It's a good question. So the answer to your question is the money received from a penalty assessment goes to the general account of the U.S. Treasury. So it goes to the general account of the U.S. federal government. It does not go to the communities or aggrieved parties directly. However, ways of mitigating or reducing penalties can be to provide some kind of restitution or mitigation to the community that is harmed. Again, some of the ways that you might be able to reduce a penalty amount is by mitigating the failure to comply, meaning fixing the failure. In addition, providing restitution in the form of either direct or in-kind payments to aggrieved parties is another way of reducing the penalty amount. An example of this kind of restitution or remediation, maybe is the better term here, would be if a museum or federal agency, if a museum were willing or able to pay for some part of the costs of to the tribe for reburial or repatriation. Those might be ways in which a penalty amount could be reduced through that remediation. So you are correct that the penalty and the payment itself does not go back to the communities that are harmed, but there may be ways to reduce the penalty amount to a museum by mitigating the failure or other means of remediation. You resort, and the top of voted question is, how would any person who may file an allegation of failure to comply be legally protected from retaliation and potential other harms? Thanks for the question. Unfortunately, there is no way for protections to the person that makes the allegation. The civil penalty process requires some disclosure of the person who made the allegation to the museum through the process of civil penalties. And again, let me turn back to our response in the regulations, because we address this in particular. In our comments, we received a number of comments about the opportunity for allegations to be filed anonymously. And unfortunately, we cannot provide for anonymous allegations in the regulations. The Assistant Secretary needs to have the ability to gather information on the allegation, and that requires that the person making the allegation provide a way for us to contact them. However, we do add in the regulations, and again, I'm reading directly here. Let me share my screen so you can see what I'm reading. However, an individual could submit an anonymous tip regarding a failure to comply. While an anonymous tip would not be considered an allegation, an anonymous tip could provide information to the Assistant Secretary to investigate and determine if a failure to comply has occurred. So we do require that an allegation include information about the person making the allegation, including a way of contacting them. But again, there could be an anonymous tip that was sent as opposed to a allegation of failure to comply. Okay. All right. Let me sort here again. And the top question is, if an institution has custody of human remains, but not possession or control, is it a violation to transfer it out of the institution? Okay, so there's a little bit to pick apart in this question, so let me try to do that. An institution has custody of human remains or cultural items, meaning that they do not have possession or control. And again, we've defined possession or control in the regulations. Let me pull that up to assist with this answer. We've defined both custody as well as possession or control, but for the purpose of this answer, possession or control means having an interest in an object to independently direct, manage, oversee, or restrict the use of an object or item. The question kind of confuses me a little bit because if you have the ability to transfer an object, that indicates the ability that you have some kind of ability to directly and independently manage. So it indicates some element of possession or control in the ability to transfer. However, I think the point of the question here is that with the question of when can someone transfer a collection of human remains or cultural items and not be in violation of NAGPRA. So, okay, I think maybe looking at, rather than the possession or control or custody issue here, a question of a private individual that has a collection and was going to transfer it to some other person. If that transfer is outside of NAGPRA, because the person with ownership does not a museum under NAGPRA, then that transfer would not be a violation. In addition, transfers between institutions that have NAGPRA responsibilities is allowable. What is not allowable is for an institution that has NAGPRA responsibilities to transfer a collection to someone that does not have NAGPRA responsibilities. That transfer out from NAGPRA to an entity without NAGPRA responsibilities is a violation of NAGPRA and could be a failure to comply. Again, where a transfer is intended to avoid NAGPRA, that is where the transfer could be a violation of NAGPRA. Okay, let me stop sharing so I can better see my questions. And again, please type your questions into the Q&A. We are unable to do any verbal questions or through hands raised. When was the last failure to comply determined, and when was the last penalty, last civil penalty assessed? I don't have the answer to those questions in front of me. I can, and I guess we don't report the dates of the failures to comply in the program reports that I shared earlier. Those program reports do indicate the failures to comply and the amounts. And I can tell you that as we reported in fiscal year 23 report, that there was no change in that report on the number of allegations that were substantiated. I'm sorry, I'm trying to answer the question based on our reporting. I can say that again, we are nearing the end of our fiscal year, and any failures to comply that were substantiated in the last fiscal year will be reported in that program report. And when was the last civil penalty assessed? Again, we don't include the dates of the penalty assessments, although we do include when there are multiple, when a museum has multiple substantiated allegations, we do include those dates. And you can, again, I'd refer you to the information that is in our fiscal year 23 report. Okay, museums run by tribal entities are becoming more popular across the country. Would tribal museums also need to submit summaries? And the question is NIDs, but I think that the might be notices of inventory completion or inventories. The question of whether a tribal museum must comply with the museum requirements under NAGPRA is really dependent upon the particular case of the tribal museum. I can't really answer generally that all tribal museums need to submit summaries or inventories. Rather, some tribal museums have submitted summaries and notices of inventory completion, and you can find those again through our website and on our databases. We'll record those, and in those cases, it's because of the collection and the nature of the collection the tribe had that the tribal museum determined that it was required to comply with NAGPRA. Obviously, many tribal museums, if not all tribal museums, receive federal funding. Tribes, generally, Indian tribes receive federal funding. And so the question really for tribal museums is if they have possession or control of Native American human remains or cultural items. And if that possession or control, how they receive that possession or control really is the determining factor there, as well as the nature of the collection. So there's too many variables for me to say yes or no to your question, but it is something that tribal museums need to keep in mind, especially about the collections that they have and how those collections were acquired. And again, we have several examples of tribal museums that have determined that they are required to comply with the museum provisions of NAGPRA. Okay. Related to an earlier question, what if you are a repository and the institution that has control is not abiding by the timelines? All right, I paused there for a minute because the question actually confuses the definition of possession or control. Possession or control means that ability to independently direct or manage the collection, and it's one term under the revised regulations. I think what the question is, if you're a repository that only has custody but does not have possession or control, and the institution that does have possession or control is not abiding by the NAGPRA timelines. I guess what can you do? Well, any person can allege a failure to comply. So if you wish to, you could allege that that entity that has possession or control and is not following the timelines is failing to comply. Outside of a failure to comply, certainly a repository that has custody has some obligations to care for collections under the duty of care requirements in the revised regulations. and also has a responsibility for ensuring that the federal agency, if it were a federal agency that has possession or control, is aware of the collection through the requirements in section 10.8. Okay, let me just resort the questions here for the most upvotes. The next question we have is regarding federal funding. Does that include funding that comes to a museum through an organization that receives federal funds, so not from the government directly? Yes, receipt of federal funds can be through indirect receipt of federal funds. Let me go back again to sharing my screen and the definition of receives federal funds. Again, receives federal funds means an institution directly or indirectly receives federal financial assistance after November 16th, 1990. And that can include any grant, loan, agreement, other use of federal facilities. This term includes federal financial assistance provided for any purpose that is received by the larger entity of which that institution or agency is a part. So again, we have an example here in the regulations themselves that says an institution or agency that's part of a state or local government, and the state or local government receives federal financial assistance, then the institution receives federal funds for purposes of NAGPRA. So yes, it may be that a larger organization receives federal funds, and that means that a part of that larger organization also receives federal funds. It doesn't have to be direct to the museum. In the case of a county, for example, where a county museum has NAGPRA collections and the county receives federal funding from any federal source, then the county museum receives federal funds for purposes of NAGPRA. Does this apply to the Smithsonian institutions? No, it does not. Thank you for asking the question. I did not answer it before. NAGPRA specifically does not apply to the Smithsonian. Rather, it only applies to museums and federal agencies, and both of those definitions exclude the Smithsonian. The Smithsonian is required to repatriate under a separate and earlier requirement as a part of the National Museum of the American Indian Act. So there are repatriation requirements on the Smithsonian, they're just not under NAGPRA. Okay. In calculating penalties, how does the Assistant Secretary determine the archaeological, historical, or commercial value? I'm especially curious about the archaeological or historical value assessment. Thanks for the question. That language comes actually directly from the law itself, again, as ways that in assessing a penalty, the secretary or the assistant secretary can consider archaeological, historical, or commercial values. There are many ways that might be assessed or evaluated or determined, and I can't really give you any examples, although I think there are many ways that the value, the monetary value could be determined. I will again remind everyone that the revised regulations have also included, in addition to those values of archaeological, historical, or commercial value, also include ceremonial or cultural value as identified by aggrieved parties. I think that how those values are calculated would depend very much on the specific examples. Okay, let's see. I appreciate those of you who've shared links in answer to other questions. How are NAGPRA violations handled for Subpart B? meaning the protection of human remains or cultural items on federal or tribal land. Would those be criminal complaints, for example, if someone illegally excavates a Native American burial on federal or tribal land? Definitely, the NAGPRA criminal provisions include illegal excavation, but in addition to NAGPRA, of course, there are other protections of archaeological resources in particular, but historical resources generally on federal or tribal land. And that would be, there are also civil penalty procedures under the Archaeological Resource Protection Act. And so someone who is illegally excavating a Native American burial on federal or tribal lands, there are any number of ways that with those violations might be prosecuted, and either criminally under NAGPRA or even civilly under ARPA. Okay, we have a question and an answer, so I'll go ahead and read those. Let me see what else we've got here. Yeah, we published our notice of intended disposition and we're past the 30 days. There are no competing claims. Is there another form that we need, or can we reach out to the claimant and work on transfer? So again, a notice of intended disposition, let's just be very clear here. We're talking about Subpart B, which is protection on federal or tribal land. If in fact it is a notice of intended disposition on federal or tribal land and the 30 days has passed, then the next step in the process is to consider a claim for disposition. And Mariah has helpfully linked to the regulatory language there. And the follow-up, though, is about using a repatriation statement. And this is where we've jumped the shark, so to speak. A notice of intended disposition, and that disposition process is under Subpart B for protection on federal or tribal lands. If, in fact, we're talking about repatriation by a museum or federal agency, and a notice has been published and the 30 days has passed, then we're talking about different steps in a process, and we're also talking about different steps depending on whether these are human remains or other cultural items. So I want to refer you to the steps for repatriation document for that in particular. And let me go ahead and just put that in a response too, because it needs there's a little bit of confusion here about what part we're talking about. Okay, so hopefully that went through, it disappeared. Okay. Where can you apply for an NAGPRA grant is one of the questions, and thank you for sharing links to our grants page and our grants opportunity page. And then again, the notice of funding opportunity for fiscal year 25 should be posted in November. So about a month or a little bit more, we will hopefully be posting that new notice of funding opportunity for fiscal year 25. But if you want to look at the past notice of funding opportunity, you can find that through our webpage or through grants.gov is the central place that you can find any previous NAGPRA grant notices of funding opportunity. If you are interested in applying for a repatriation grant, again, funding is available now. Don't delay, apply today for a repatriation grant. Can an individual apply for a national NAGPRA repatriation grant to retrieve materials from the Smithsonian? No, repatriation grants can only be applied for NAGPRA covered repatriation. So it does not include the Smithsonian, as I answered before. In addition, individuals cannot apply for NAGPRA grants. Only Indian tribes or museums may apply for NAGPRA repatriation grants. So I'm sorry to answer no to both parts of your question. Okay, a question about the January 2025 deadline that I referenced. for federal holdings or collections. What is required under the regulations, the revised regulations in section 10.8C is for museums that have custody of holdings or of federal holdings or collections to report to the federal agency by January 13th, 2025. And let me go ahead and share my screen for this so you can see it, but then I'll put the link in as well. So there is a requirement in these regulations that a museum that has custody of a federal holding or collection send a statement to the federal agency. So it's not a summary, it's not an inventory, it is a statement for those collections. I lost the question, I'm sorry. I'm going to put this link in the chat to 10.8C. And I will also show you on our website where we have a template for a statement, and you will see that it is a very simple document. I guess I can't do that, sorry. So we do have a template here that you can download and view, and that statement is, again, a very simple document that just states that the museum has a federal agency holding their collection and information about that. And it is, those statements are due to federal agencies by January 13th, 2025. Well, this is a first, I think, that I've gotten through all of the questions that were asked in one of these webinars. And I appreciate all the questions that were asked. I also appreciate your time and attention to the presentation itself today. And I hope that you're able to follow up with the resources that I've provided through this webinar on civil penalties if you have additional questions. Again, this was the 9th webinar in our series, and we have one more. So next month in October, we will have a webinar on the review committee to round out our year of NAGPRA webinars. I will say again that we are hoping to continue to host monthly webinars next year, beginning again in January of 2025. And we welcome your thoughts on what topics or the content of these webinars. So please feel free to share your ideas about future webinars with us. You can always reach us at nagpra_info@nps.gov. And I'll put that email address in the chat as well. So thank you all for your time today, and have a wonderful weekend.